Click the screen. Yeah.
Are you listening to me?
Yes, we start, sir. Yes,
Okay,
we do start. Good afternoon, good morning, honorable guests, esteemed colleagues, esteemed distinguished speakers and participants. It is both an honor and privilege to welcome you to this crucial international webinar on intricacies of military artificial intelligence and international humanitarian law through the lens of the precautionary principles, organized by JSS Law College in collaboration with the Nairobi Law School, Nairobi University, University of Fertilizer, Brazil, Institute of Legal Policy Research, Virtual NGO. We gather here today at the moment of profound significance, when the intersection of cutting-edge technology, military strategies, and humanitarian law became focal point for the global discourse. The rapid development of technology and deployment of artificial intelligence in military operation, reshaping the landscape of warfare in a way that presents both challenges and opportunities. As the world stands on the precipice of what often be termed as the fourth industrial revolution, the role of AI in military decision is no longer theoretical. It is a reality, one that forces us to confront the questions of immense ethical, legal, and humanitarian importance. These questions are not abstract. They directly impact on the lives of individuals, stability of a country, and the very future of the global security. The integration of AI into the military systems is transforming the nature of conflict itself. We now faces the possibility of autonomous weapon system, the system that capable of making life and death decision without direct human intervention. This is so-called a killer robot. That raises urgent concerns about compliance of military operations with the principle of international humanitarian law, particularly the principle of distinction, principle of necessity, and proportionality. As we embark on this two-day journey of reflection and discussion, it is imperative that we acknowledge the complex ethical, legal, and societal, what we call social implication of this development. Our collective responsibility is to ensure that the technologies of tomorrow do not erode the value of humanity and the rule of law that we hold there. The challenge of accountability in the age of AI system, one of the critical issues, challenges, and that will occupy our discussion in the question of the question of accountability, autonomous system. By the very nature that introduced the responsibility gap, now the question arises, if the weapon system makes erroneous decisions that leads to unlawful harm, who is accountable? Is it the state who developed the AI? Is the commander who deployed it, or the machine itself? So these are not just theoretical questions, but vital concerns that must be addressed if we are to ensure justice, accountability in the era of machine and may wield power of life and death. The International Committee of Red Cross had made very clear that there is no room for ambiguity when it comes to their responsibility. But this question, it is stated as ICRC that autonomous weapon is capable of targeting civilian must be banned outright. It is more or less, it is not a legal stance, but it is just a moral discussion. One must ensure that the human dignity and civilian caught in armed conflict are not never sacrificed to cold logic of algorithms. Another critical area of focus of the issue of bias in AI system. AI by its nature is trained by data. The data is often reflected on the existing societal prejudice and inequalities. If these biases are not mitigated, AI system could perpetuate even or exhibit discrimination on the basis of race, religion, nationality, or even protected characteristics across the jurisdictions. These are the potential to violate the core humanitarian principles that underpin under international humanitarian law, including the prohibition of discrimination and requirement of the protection of civilians. We must confront that uncomfortable truth that the AI system can sometimes reproduce and amplify the very bias that to strive eliminate the human decision-making. As global community, we must demand that the state takes proactive steps to ensure that the AI technologies they develop are not only legally sound, but ethically fair and just. Beyond the legal and technical dimension, there is a deeply moral question that we must all confront. Should we entrust the decision of life and death to machine? Can, as a global community, tolerate the potential dehumanization of conflict in the world where machine rather than human determine the fate of civilian and soldiers alike? These are difficult questions. There are no easy answers, but these must be asked and debated. Because of this consequence, our collective choice today will resonate for future to come. To address this complex issue, international cooperation will be essential. AI does not respect border, and risk poses cannot be mitigated by one nation acting in isolation. We must collaborate across disciplines, culture, and legal tradition to develop a framework that ensures responsible AI that used in the military context. This collaboration must not be in alone by one nation, but this must include governments, international organizations such as ICRC, academic institutions, civil society. Together, we can build a future where the technological innovation serves as a cause of peace and security, rather than exacerbating conflict and the suffering. We must also recognize the development of AI in warfare is not static. As the technology evolves, so too must our legal and ethical frameworks. We must remain vigilant, flexible, ensuring that international humanitarian law keep pace with the technological advancement, and this requires only a rigorous legal analysis, also vigilant to adopt new realities that emerging trends. This webinar, particularly what we host, provides a unique opportunity to engage in meaningful dialogues and collective reflections. Over the next 2 days, we will explore the various dimensions from the technical capabilities to moral and legal issues around the warfare. We will share our insights and we challenge each other's perspectives. And most importantly, work together to ensure that deployment of AI in military operation aligns with the principle of justice, accountability, respect for human life, human rights, and human dignity. We are honored to have a distinguished panel of experts from the across global jurisdiction representing diverse range of perspectives on the intersection of military AI and international humanitarian law. Over the course of today's session, we will engage for the thought-provoking discussion that aim at advancing understanding of us over these critical issues. Without further ado, we will begin our proceeding with the welcome address by esteemed Principal of Justice Law College, Dr. N. Vanishri. Then it is followed by our esteemed Chief Guest, Professor Dr. Srinivaslu. Ma'am, I would like to request you please address a welcome address for esteemed.
Thank you very much, Mr. Syed Kudrat. A very good afternoon once again to all the dignitaries, speakers, and dear participants. It gives me immense pleasure to host this 2-day international webinar on, as Mr. Syed rightly pointed out, crucial webinar on military artificial intelligence and international humanitarian law through the lens of precautionary principles. So he's bringing in technology, he's bringing in international law aspects, and of course, in the light of SDGs and the law of environment, I think we have this transdisciplinary subject which has been chosen. And I congratulate Mr. Syed for choosing such a wonderful topic. At the outset, I would like to welcome the dignitaries and of course, again, like to share the chief guest, none other than Professor Dr. Srinivasalu NS, Professor of Law, National University of Juridical Sciences, Kolkata, India. And like to share that we were classmates when we were doing our LLM. He's a very good friend of mine. A very warm welcome to you, Dr. Srinivasalu. And Professor K. Suresh, the Chief Executive of JSS Law College, in his absentia, I would like to extend him a very warm welcome. And then Professor Dr. Antonio George Pereira Jr., Professor of the Doctorate Program in Law, Unifor University of Fortaleza and Washington, and from Brazil. And sir has been with us throughout, and we are coordinating programs together. Wonderful having you here, sir. A very warm welcome.
Thank you.
Yes, sir. We have Dr. Anastasia Zuravel, Center for Fundamental Rights, Hertig School, the University of Governance in Berlin, Germany. A very warm welcome to you, ma'am. Dr. Elizabeth, Peace Research Institute, Frankfurt, Germany. In her absentia, due to her due to her health reasons, she couldn't join us, but has promised to join us in the further endeavors. Professor Dr. Maruti TR, Professor of International Law, Department of Studies in Law, who will be one of the speakers. Who will be one of the speakers. Dr. Kenneth Vinay Mutama, Editor-in-Chief, East Africa Journal of International Humanitarian Law and Senior Faculty of Law, Nairobi Law School, Nairobi University, Kenya. A very warm welcome to you, Dr. Kenneth.
Thank you very much. Thank you.
Thank you, and nice to meet you again online. And I would continue to welcome Mr. Raul Cardellani, Advanced Masters in Air and Space Law, International Institute of Air and Space Law, Leiden University, Netherlands. Again, who is agreed to be one of the esteemed dignitaries and one of the esteemed speakers for this. And of course, we have with us the organizing secretary, Mr. Syed Kudrat. I'll be failing on my duty if I don't extend him a warm welcome.
Thank you.
The IQAC coordinator of JSS Law College, Dr. Jagdish, is with us here this afternoon. A very warm welcome to you, Jagdish. Our systems analyst, Mr. Madhukumar, is there throughout with his untiring support in all the online and the offline programs of our college. Welcome, Mr. Madhu. Our student coordinators, Ms. Jahnavi and Ms. Ghana, are here. In spite of their examinations, they've extended their time and support for this program. A very warm welcome to you. Last but not the least, to all dear participants who have already, already made this program successful in the very beginning of the session itself. Once again, I welcome on behalf of JSS Law College and on my personal behalf, every one of you to this two-day international webinar. And I also congratulate to have very good deliberations at the end of these 2 days program. Thank you very much.
Thank you, ma'am, so much. It is my privilege now to invite esteemed Professor Srinivasalu, a professor of law, and we are grateful to have him today with this our program. Before I invite sir, I would like to request Ms. Ghana to introduce sir to the audience.
Yes, sir.
Please.
Today, we are honored by the presence of Professor Dr. Srinivasalu, NS. He's a professor of law at the National University of Juridical Science, Kolkata, and a distinguished member of the International Council of Jurists, London, and the Canadian Institute of International Law. He's also associated with the World Commission of Human Rights, London. A former faculty member at the NLSIU Bangalore and University of Mysore, Professor Srinivasalu sir has over 110 research publications, including 7 books, 3 monograms, 9 edited volumes, 15 book chapters, and 75 research papers. His work has been featured by the eminent publishers like Oxford, Penguin, Springer, and LexisNexis. Professor Srinivasalu sir has provided policy advices to the Indian Ministry of Justice, Ministry of Commerce, Ministry of HRD, Ministry of the Transport, along with the state governments of Karnataka, West Bengal, Assam, Goa, on legal education, law, and policy making. We all welcome you, sir.
Thank you, sir.
Thank you. Thank you. Thank you very much, Vani, for such a warm welcome. Because in Kolkata, the weather is very cold, so I need the kind of warm welcome that you are giving. And I still remember the 2003 February cold rise that you sought.
Thank you very much. Thank you very much.
So, nevertheless, I start with a caveat because this topic that you have chosen, artificial intelligence usage in military in the context of humanitarian law. I have been telling from past 2-3 years already that because of the development of science and technology, especially in the field of forensic science, in future you may not get to see people like you and me giving witness in court and police station. The criminal justice administration investigation and prosecution will happen without the presence of any natural or normal human being. Everything will be based upon digital evidence by the use of satellites, right? Such being the case, in future, military operations will be purely by the use of artificial intelligence only. Normal human beings will not participate in any war, right? There will not be any battle that we used to see in olden days, or the way Rajamouli has portrayed in Bahubali and all that. No physical use of any force. And the physical use of force, war, crime, or wartime operation, all these things are very much established principles of international law. All these things are going to have a great change because now use of force is not going to be based upon human intellect. It will all be based upon artificial intelligence, right? So as I mentioned, the context of humanitarian law that you have brought into this discussion, right, may not be that much relevant in the days to come, especially in the context of military operations based upon artificial intelligence, because only artificial machines, robots will be participating in military operations. So that the question of humanitarian law may come only with respect to civilians and citizens. It may not be in connection with the army or military forces, because the entire army and your military forces, military operations, all that will be based upon AI, machine related tools and your robots. Nevertheless, since 2015, if I'm not wrong, nations like USA and China have been using artificial intelligence in their military operations. It is nothing new to them. I'll give an example. Even before 2015 also, especially Barack Obama administration since 2008, they have been using artificial intelligence. You must be having a clarity and a clear idea with respect to how Osama bin Laden was killed when he was hiding in the border area of Afghanistan and Pakistan. When Barack Obama was personally supervising that operation, and they were bang on target, right in point blank. They happened to shoot Osama bin Laden. How that happened? It all based upon satellite and artificial intelligence. More than a human army participating in that operation, satellite help was taken, and based upon the reflections and results given by the artificial intelligence with respect to where he is and in which part of the world that person is hiding, in which location, in which house, in which bedroom, in which corner he is hiding. All that was traced, located based upon satellite signals and by the use of artificial intelligence. So that we all know how that operation took place, because it was a big news at that point of time, especially during Barack Obama's second term before Trump took over. So that happens to be a classic example where the satellites and artificial intelligence was used by US for its military operations. Aftermath of which China, as we all know that now unlike Russia and America's Cold War times that we have seen during our childhood and all. Now it's between China and USA. They are actually the two top nations with respect to anything. It could be based upon economy, market, or it could be military strength, or it could be the ranking that you would like to give based upon their financial status and all that. It's always China which is seconding to US now. Here also in the question of use of artificial intelligence for military purposes, China also has begun doing it from 2018 itself. Of course, people say that we don't have any law either at national level, regional level, or even at international level with respect to the regulation of use of artificial intelligence in general sense. And here, in particular, with reference to military operations or use of AI for military purposes. Whereas United Nations in 2023 itself, last year, happened to come out with a mission that by 2026, they would like to have some international law, some treaty to be adopted with respect to regulation of the use of artificial intelligence in military operations. And of course, it goes without saying that till today, the legal spectrum is unable to figure out the kind of status that we would like to give to artificial intelligence. Its status, its personhood, the kind of entity that it is, we are still unable to figure it out. Nevertheless, because of the fact that use of artificial intelligence is happening across the globe with respect to any field, not only confined to science and technology, any field for that matter, down to dusk, we are using AI. Therefore, the United Nations, the General Secretary issued a notification in 2023 July itself that in the coming 3 years, that is by June 26, United Nations would like to have some draft treaty with respect to the regulation of use of artificial intelligence in general and as well for respective use of the same in military operations. And of course, as we know, especially the scholars of international law, they know it very well that in the making of international law, it's always the United Nations which plays a pivotal role. In fact, they not only come out with some draft rules and regulations which they test it out in their frontiers, and the same they would like to ensure that the entire international society accepts that. If you look at the human rights treaties, you take environmental law related, labor law related, and even WTO related treaties, agreements, conventions, whatever that have become the order of the day across the globe. All those treaties and conventions emanated from USA to begin with, afterwards of which they evolved to become international law as such. In a similar way, even with respect to the regulation of use of artificial intelligence as well, USA, the current administration, Kamala Harris, the vice president, happened to come out with a declaration that that is called as US AI Regulation Declaration, that they would like to go for the responsible use of artificial intelligence to ensure that there is global peace. Responsible use of artificial intelligence for ensuring global peace, to which about 50 nations have consented already. Of course, India is not a party to it because it is not a formal piece of international law as such, but USA is trying to come out with some draft policy as such. I'm sure in the days to come, United Nations will take it forward. Our USA, as one of the most powerful 5 members of the Security Council, has got every strength to push it forward, right? So what I'm trying to say is, at international level, at US level, certain legal formulations are taking place with respect to regulation of use of artificial intelligence for ensuring that it is used with utmost responsibility, and at the same time ensuring that there is no adverse impact on the environment and it doesn't result in violation of your human rights principles or the principles of humanitarian law. But when it comes to India, very recently in July 2024, our defense minister of the country, Mr. Rajnath Singh, he happened to come out with a policy that hereafter Indian military would use artificial intelligence in its military operations. It does mean that following the footprints of USA and China and such other countries, India has also started using artificial intelligence in its defense and military operations, right? Two developed nations and one developing nations like India. All three nations that I mentioned, USA, China, and India, are big markets. They have got gigantic personality in terms of international relations. So what is happening in these three countries, the most populous countries, right? China, India, and USA, which share more or less 40% of the population of the entire globe. The developments that are taking place in these three nations would definitely have impact as far as the evolution of international law is concerned with respect to regulation of use of artificial intelligence, not only in general sense, but with respect to the military use and military forces. I always say, as far as the regulation of science and technology is concerned, as a legal scholar, that more than we talking about formulating and reformulating the existing law or coming out with a new law, for any new development of science and technology or the deployment of a new technology for whatever purposes, including military purposes, I always say, and I firmly even today believe, that our law of tort, common law, whatever we call it as, is having enough to take care of any contingency or to care of any eventuality with respect to use and deployment of technology and technological tools with respect to the international relations and regulation of such use made for any purposes, including military purpose. Because the law of tort, the common law, the law of precedent, whatever we call it as, it is based upon wisdom. It may not be the formal law. It may not be the law that we call as that has come out evolved through imperialistic mechanism, but it is based upon wisdom, the rationale, what we call as the prudency of the common man. The civilized nations' consciousness gets reflected in the law of tort. Therefore, when we are talking about the regulation of use of artificial intelligence for military operations or military purposes, while trying to balance the environmental concerns and ensuring that humanitarian law is also respected, I have got two important points to make. One is that in the days to come, no human participation will be there as far as military operations are concerned. It will all be through artificial intelligence and robotics. So the application of humanitarian law will be restricted only to the civilians who may have the adverse impact of who may get subjected to some damage whatsoever because of the wars and things like that, as it is happening now between Ukraine and Russia or Syria and Iran. And the humanitarian concerns with respect to military operations or military people, that may not be there, number one. Number two, in the modern times, when you are using artificial intelligence for military operations or military purposes, the environment concerns will be again from a technological point of view. The evolution of artificial intelligence is happening in such a way that it may not cause any serious damage to the environment or to the civilians. I'll give an example. We have now a fair amount of idea with respect to what are the different tools of artificial intelligence, different models of artificial intelligence. I'll talk about two different models. One is the generative AI. The other one is multimodal AI. Generative AI, as we understand, it evolves on its own. It learns on its own, right? Like your chat GPT and all, where the human intervention will be very limited. You may create a program, computer program or algorithm-based code of conduct for it to begin with. Afterwards, it will be on its own. It generates knowledge on its own. It takes decisions on its own. And especially in the field of war or in the military operations, launching drones, taking care of the surveillance, checking out which area, which type of troops are there. So all that is done by AI, because this AI is self-generative, self-evolving, right? So these type of AI models are going to be operational, number one. Number two, we are now, the recent AI model is multimodal AI. right? Earlier, any type of artificial intelligence model would have some restrictions that it will only listen to your audio, or it will only read from text messages, or it will only read from the images, or it will only follow audio-visual response, right? So now the multimodal AI, whatever I'm trying to talk about, is going to have the capacity of all that. You may give command in whatever way: text, image, audio, video. Or if it is a generative AI, it will try to fetch information from all the different ways. It may hear something, it may see something, it may read from something, so like that. So we call it as multimodal AI. So when you are deploying multimodal AI for military operations, right? So it not only seeing which type of troops are coming in your way, it can hear, right? It based upon the images that you supply, or based upon the images that your satellite supplies, right? Because satellite will send you pictures with respect to in which border, what type of situation is there. That picture, your satellite may give you, and your multimodal AI reads from that picture also, that image also, right? So such kind of multimodal AI is coming into picture now, right? To make it more easier to understand, I'll give an example. We talk about automotive cars. We talk about cars, driverless cars, or driverless trains, driverless metro, and all that, which operates on their own, right? Without any human being or individual to drive these automobiles. In such scenario, in case of any accident takes place, who is going to be responsible? Who is going to have liability? All these things we have been debating. That is because these automotive motor cars, they are unable to see what is coming in front of them. They are only given instruction that this much of length you have to travel, and these automated cars will just travel. If any human being is coming in the way, accidental, or any animal is coming in the way, they are unable to see it because audio visual is not operational for them. Or if they are seeing any picture, suddenly a small auto or car is in the way on the track, it cannot see it because it's an image for it. Or there is some sound, somebody is saying stop, help, and all that, it is unable to hear it because it's only based upon a written instruction. Now, not only instructions in writing, now the automated cars are going to have that visual sense, ear sense, and they can see the pictures, graphics, and all that. That is all the 5 biological senses, whatever you call it as in terms of human being. In the similar way, the multimodal AI is bestowed with all the different types of biological senses that we are having. That's why human intelligence-based artificial intelligence that is being bestowed in multimodal AI, right? Like human beings, we can see, we can feel, we can hear, we can smell, we can touch. All the 5 senses are now getting bestowed in this model of AI, wherein just like a human army who can sense the things around in any military operations, a robot can also do the same. Because now robot is not going to be operational based upon only written instructions. It can hear also. It can see the images. It can see any audio visual as well. So it is nothing but replica of human intelligence, right? Now AI, multimodal AI in particular, has gone to such a level that you are more or less replicating human being, right? It's not just about the administrative AI or generative AI that we have been talking about all along till 2023-24. Now, especially for military operations, this multimodal AI is being evolved now, which does nothing but just like you and me. And it is a device designed basically to suit this kind of purposes: military purposes, protection purposes, police purposes, defense purposes, because it will have not only 3D effect, all the 5 biological senses that we contemplate for human being, all those senses are going to be bestowed in this multimodal AI. And when that is happening, your humanitarian concern that you are trying to address in this conference, you say that AI is not thinking like human being. It doesn't have human civility. It doesn't have emotions. So when you deploy AI for military, it will obviously doesn't bother about human rights or humanitarian concerns, right? That is one focal point that you are trying to address. But with this multimodal AI, those concerns are, I don't say completely, to a great extent are going to be addressed, because this multimodal AI is going to behave like human being. That human intelligence, human concern, right? Human rights understanding, and more importantly, emotional things that you and me will have based upon all our 5 biological senses are going to be held by this multimodal AI. And I believe this is going to be a great contribution for addressing not only our humanitarian concerns, but as well environmental law related concerns, because one sense of human being says that no, we need to sustain the nature, preserve the nature. We need to respect the fellow human being, right? We have emotions, we have love and affection, all that, whatever you call it as a human beings concerns, and which are getting reflected in your humanitarian law, and which are getting reflected in the process of you conserving and sustaining your environment and the nature, mother nature, are going to be now bestowed in this multimodal AI. And in the days to come, maybe 25, 26, you will have this model which is going to behave like a complete normal natural human being. That's why I say it is not just artificial intelligence, it is human based artificial intelligence, because all the human senses are getting bestowed in this new multimodal artificial intelligence. I believe with this model, your humanitarian concerns, environmental concerns are going to be addressed in terms of be using artificial intelligence for military purposes. With this few words, I would like to stop here. I'm sure that in the 2 days, you are going to throw light on a number of such issues, and I believe whatever I got to say in this concern is going to be only a small step in formulating and in evolving further jurisprudential development and evolution of law regulation on this issue of use of artificial intelligence for military operations, while throwing some light on humanitarian law and environmental concerns. Thank you, one and all, for giving this opportunity, and thank you very much.
Thank you, sir. Thank you so much. We are really delighted to have you with this program. Now we shall move to the second speaker. I would like to request Professor Dr. Mutuma to give his insight on the Africa's vision on military AI and commitment to international humanitarian law. Before we move to the Dr. Kenneth, sir, we would like to brief about your academic profile, please.
Thank you, sir. It is my distinct honor to introduce Dr. Kenneth Wine Mutuma, is a senior lecturer at the Nairobi School of Law, University of Nairobi, with over a decade of teaching experience. He specializes in international humanitarian law and lends his expertise to academia, government, and civil society across Eastern and Southern Africa. Dr. Mutuma has served as a legal officer at the United Nations High Commissioner for Refugees, that is UNHCR, contributing to refugee policy implementation in the Great Lakes and Horn of Africa. He also worked with the International Committee of the Red Cross, that is ICRC, in Nairobi and Pretoria, promoting international law in conflict situations. Additionally, his work with the Nelson Mandela Foundation focused on building governmental and civil society capacities in conflict resolution and ethical leadership. Holding a PhD on the challenges of outsourcing war to private entities, Dr. Mutuma is the author of the seminal work, International Humanitarian Law, Themes from Africa, which provides an African perspective on IHL-related debates. Dr. Mutuma will speak on Africa's vision for military artificial intelligence, a commitment to international humanitarian law, exploring how Africa can integrate cutting-edge technology into its military strategies while upholding the principles of IHL. Join me in welcoming Dr. Mutuma. Thank you.
The floor is yours.
Yeah, thank you very much to the esteemed organizers. It is always a pleasure to be able to join you. We have been doing a lot of work with Missouri University in this area, particularly in the area of publishing on aspects of international humanitarian law. I would like, from the very onset, to throw a spanner in the works on this topic. Bringing in Africa's perspective, I think from the very onset, you will realize that the continent has been playing a bit of catch up when it comes to matters AI and military technology. But before I do that, let me just make some foundational remarks in relation to the subject at hand. The first, I think, is to recognize that the essence of the evolution of warfare at different stages, and I think this is what makes AI very peculiar, because we are in the last and fourth stage of this evolution. At different stages, the law has sought to respond with basic principles on how to contain how humans prosecute and defend war. And there are four distinct stages, I think, that come to mind when you look at the evolution of armed conflict. I think the first era of military development was prior to the age of machines, where kinetic energy was, as it were, in its bare essence. This is the swords, spears, stones, catapults, and so forth era. Of course, that gave way sometime in the 16th century to the age of machines, and very specifically machines that human beings were controlling. That age, of course, culminates with the Industrial Revolution in the 19th, 18th century, where you have this massive multiplier effect. At the same time, you have a huge spurt in the growth of the law to contain that industrialization of the means and the methods of warfare. This was the time, of course, that a lot of the modern codification of IHL then begins to arise with the concept of neutralism, the concept of humanitarianism, and for those of us who, of course, are aware of the subject, the rise in Geneva of the very early movements in this regard, led by the writing of Henry Dunant in A Memory of Solferino. We are now in what many view as the new age, where there are contemporary means and methods that have started to, as it were, blur and challenge the very essence of kinetic warfare. And three very specific contexts arise. One, of course, is the question of cyber warfare, autonomous weapons, and of course, the use of AI in all its forms, general AI, super AI, and what you had earlier on from our chief guest, multi-AI. So that foundation is very, very key, because we begin then to juxtapose the philosophy of international humanitarian law on the very, very final stages. And that philosophy finds its root in the just war doctrine. So at the very early genesis, for when human society was evolving, the social reality of war needed to be contained. And the first response on how to contain that reality was in the elements of the just war doctrine. And there were three specific elements that then stand out in this regard. The first, of course, was the idea that somehow there needed to be some legitimate authority in which the prosecution of a conflict was vested in. And I'll come back to that because machines and even more complex AI begin to question the idea of what is, where should that legitimacy sit when it comes to the prosecution of war. So we saw in different stages how that legitimacy then ended up being centralized through in the state and its organs, its actors, what is more specifically thought of as international law as the effectiveness of government or the monopoly of violence in which the state holds those instruments. The other element in the just war theory which was very, very key in trying to regulate the social reality of armed conflict, was that of intention, the legitimate intention, that not that in a conflict, that only certain intent was sacrosanct and worthy of protection when it came to either offense or defense. And that intention, of course, started being carved out in what was then considered as acceptable means and acceptable methods of warfare. The third element that was very, very key was the idea of that the idea of proportionality, that the means that you used had, as it were, limits that they could not go beyond. This third element, of course, finds its way, it cuts across what IHL practitioners refer to as use ad bellum and use in bello, but with very, very different means. That even when prosecuting a conflict, that there were limits to what could or could not be done. That language then finds its way in a lot of what the early proponents and philosophers such as Jean-Jacques Rousseau have sort of coined as the purpose or the objective of an conflict. It is not to annihilate or to consume the adversary, but it is to neutralize, or at least effectively see the adversary unable to be a threat. And anytime that neutralization is reached, then there is no need of going beyond that. So that the idea of proportionality. Now, the question then we ask in the context of the contemporary phase is whether whether we have found a way to safeguard those early foundational aspects of the just war doctrine as they would apply in the current or in the modern scenario. Now, so far, what's been happening in the continent, Africa has been grappling with kinetic energy. And even in that world of kinetic warfare, as it were, you can see that there have been difficulties in honoring, honoring and implementing and enforcing the very crystallized legal framework that seeks to safeguard and honor the idea, and these are three specific ideas. One, that in a conflict, that there are certain persons that are active members and there are others that are not active in that conflict. And these two different groups need to be treated separately. What we refer to as the fundamental axiom of distinction inside the terrain of battle. We have seen more and more that terrain being heavily diluted in many, many instances with what we call the civilianization of armed conflict, as more and more the distinction between who is a combatant and who is a civilian is going to be questioned. Now, what does that mean once you introduce machines? And of course, when you introduce very specifically intelligence within the specter of machines. So you can see that space and that blood zone is likely to be even drastically made more complex. The other area, I think, we still have gaps in enforcement, and even within the kinetic space, and they are likely to be multiplied in the other context, is on the question of scope, when or when not an armed conflict arises. IHL, of course, and the very nature of regulation starts when that threshold has been reached. And even in the kinetic sense, there has been struggles between when you move from internal disturbances and tensions into, as it were, what now is regulated either in the context of international armed conflicts or non-international armed conflicts. Because, and particularly in the latter context, the ideas that were espoused and continue to undergird the field jurisprudence, the ideas that are in tadage around intensity and threshold become even more complex when you introduce the age of machines and these contemporary means and methods of warfare in the language of AI. The third, of course, and of major significance is this sacrosanct line that the law tries to divide, to create between use ad bellum and use in bellum. That in the context of the law of war, that there should be these three phases, before, during, and after war, and it's very important to keep those phases separate, so that you can have effective regulation. In other words, the legality of warfare should not be then confused with the regulation of what is acceptable during the warfare, so that one may be an outlaw before or at the commence of war, and they may have prosecuted a war for all the wrong reasons, but they can be the most abiding, quote unquote, entity once that war breaks out, because they conduct themselves in a particular manner that upholds the law of war, or what we call, as we popularly refer to as jus in bellum. That again becomes very, very complex in the age of machines, and specifically AI, because when and how those stages are transposed becomes much more difficult to design. It becomes more difficult to design what the creators of machines, the extent that they are proximate to the war, and indeed when those machines themselves have an intelligence, and they contribute to matters that then could blur those three steps. The last, of course, is, and it's a huge debate, is this lens on the humanization of or dehumanization of conflict. So conflict from the very early stages has been very blood and very gory and very brutal, and it has made it a bit easier for society to respond when it comes to calling out what is or what is not acceptable. The world of AI as a contemporary means and method of warfare does create some complexities. On the one hand, of course, there are those who speak about the clinical surgery side of the introduction of this the idea of machines in terms of its precision and the ability to limit the casualties and to impact on all the four broad pillars in which the conduct of hostilities is undertaken. The idea of distinction, proportionality, precision, and military necessity, because of the accuracy that AI and machinery would sort of bring into the field, that we are likely to see less infringements. On the other hand, of course, there are those who are very conscious that the very fact of distance in which technology creates between combatants, you will start to see what IHL practitioners and psychologists refer to as the dehumanization of conflict. And what that means is essentially it becomes easier to occasion much more severe damage and pain, because the idea of pain and suffering is now further and further removed from us. And that, I think, is where the problem is, because then the urgency of regulating conduct becomes more and more remote. The last, of course, is the question of culpability and responsibility in the background of those comments that I have just made on that IHL is really being responsive and tried to peg capability based on the reality of what is happening on the battle zones and in the battle theater, the pain that is occasioned, and then, of course, who should be responsible for that. Now, AI contemporary warfare creates, again, difficulties. And at different stages, we can see how IHL has sought to peg capability and surmount difficulties as warfare has adjusted, including the very novel introductions at the turn of the 20th century after the world wars of individual criminal responsibility in international law and command or superior responsibilities between what is effectively a principal agency relationship that is designed in war. But all of these aspects assume that that somewhere, somebody, somewhere, somehow, there's a human being that is controlling the activity. That is where we run into significant difficulties, difficulties that continue to even become more and more exacerbated in the context of cyber warfare, autonomous weapons, but I think more particularly in the extreme context of artificial intelligence and the ability of machines to learn and to operate independently of a human hand. So that, I think, is where a lot of the discussions have been on the continent, and answers are still being sought. A lot of those answers, of course, take the form of the soft law and the evolving nature of discussions that are happening at both at national level, I think, in different contexts, in East, West, and Southern Africa, and also within the Africa Commission of the African Union. There is one part in those discussions that has taken a leap, and purely, again, because of the pragmatics of what states need to do in response to lived realities in their countries, and that is on the evolution of data as a tool in which both prosecutors and defenders of in the context of cyber warfare may resort to. Now the data, of course, the evolution of data in the context of cyber warfare is something that does not fall strictly within what is understood to be the scope of an armed conflict. It may arise before or after an armed conflict. Remember the earlier discussions that we had on the complexities of scope once you introduce the digital era. But because of so much of what has been happening in the world of trying to secure data and in the world of specifically privacy of data, we have seen a proliferation of legislation that essentially begins to tease out what is likely to be the kind of standards that extrapolate themselves in the context of war as this becomes clear. And you will find key principles in which legislation across African countries are starting to harness or hone around. One is the principle of lawfulness, accuracy, storage limitation, confidentiality, and accountability. The last one is very, very key because the elements in which that accountability are being forged are likely to be some of the elements that find their way also into the context of AI and the militarization of conflict. Allow me to stop there and thank again the organizers for always putting together what I think IHL particularly means is this idea of transnational and across continents university cooperation in scholarly work and looking at contemporary and thematic areas that are emerging. Thank you. Thank you again, and I hand over back to the organizers.
Thank you, sir. Thank you so much for your thought-provoking speech. Actually, you are also the coordinator of this program. Thank you so much for you that you have provided this opportunity. Without you, it would have not been so successful. So we are honored to welcome Professor Dr. Antonio Jorge Pereira Jr. from University of Unifa, Fortaleza, Brazil. Before starting the stage, we would like to brief Sir's biodata, then I will take the floor.
Thank you, sir. Professor Dr. Antonio Jorge Pereira Jr. is a distinguished legal scholar recognized for his significant contribution to the family law, civil law, and children's rights. He holds a doctorate in law from the University of Sao Paulo, Brazil, where he has completed his master's dissertation on tutelary counsel, socio-legal foundations of the supervision and guidance of family power by the society and state. His doctoral thesis, Right to Formation of Children and Adolescents in the Face of Open Commercial TV in Brazil, earned the prestigious 2007 News Agency for Children's Right Award. Professor Pereira is expertise widely acknowledged with his work winning the Orlando Gomez Elson Gottschalk Legal Award for both his master's dissertation and doctoral theses, conferred by the Brazilian Academy of Legal Letters. He has held academic positions at esteemed institutions, including the University of Sao Paulo, Sao Bernardo do Campo Law School, and Sao Paulo State University, Julio de Mesquita Law. A dedicated member of the several law and academic institutions, Professor is affiliated with the Institute of Lawyers of Sao Paulo and Sao Paulo Academy of Legal Letters, the International Academy for the Study of Jurisprudence of the Family, and American Academy of Family and Personal Law. He is also the member of the Constitutional Studies Commission and the Brazilian Arbitration Committee. As a lawyer, he is regularly registered with the OAB, SP, and OABC. Additionally, he serves as the evaluator for the Ministry of Education. Today, we are honored to have him with us to share his insights on Brazil's leadership in military AI governance, a commitment to international humanitarian law. Thank you, sir. Please, I welcome you.
Thank you all for this opportunity. For me, it's a great honor to be here with you and heard our colleagues that spoke before me. It was a very good opportunity to learn about the topic. So I think I will just get some of the dilemmas of this topic that you heard about our two friends before me. And after this, I will talk to you about something in Brazil, what in Brazil we are doing just now to run off this topic, you know. Well, I think my colleagues that spoke after before me, the ethical dilemmas from this topic is autonomy and lethal decisions. The ability of autonomous weapons systems to make lethal decisions without direct human intervention raises questions about the morality and ethics and delegating life or death decisions to machines. It's a very great dilemma. Second, responsibility and accountability. The difficulty in attributing responsibility for actions taken by autonomous systems, whether in terms of legal, moral, or military accountability, raise on accountability vacuum. Discrimination, the third dilemma, and the distinction. The ability of AI to distinguish between combatants and non-combatants and to adhere to the principles of proportionality and necessity is crucial for compliance with the laws of armed conflict. Fourth, conflict escalation. The use of AI and weapon could lead to a new arms race and potentially to an escalation of conflicts. We're just now looking at what happening between Russia, for example, and Ukraine. Given the capacity, or in Israel and in other countries there, given the capability for faster operation and decisions made without human hesitation. Five, security and malfunction risks. The possibility of malfunction of AI systems being hacked and misused presents significant risks to global security. So, of course, the law needs to think about this and how to manage this, how to put our hands on it. It's a very difficult topic. We can put legal perspectives for addressing this. Development of international norms, the creation of treaties and specific international norms for the use of AI in weaponry. So I'll talk after this what Brazil is doing in this topic. Similar to existing conventions and on chemical and biological weapons, and establish clear limits for the development and the use of these technologies. Second, national regulations. Indian, Brazil, Russian, South African, United States. Well, countries can develop their own international regulations that define the ethical and the legal boundaries for the use of AI in weapon systems, including requirements for human oversight. Of course, this topic it's very different from country for other country because the experience in wars, for example, wars. No? Of course, Brazil, for example, we don't have a very great history about the wars. But if you think about the United States, Great Britain, Russian, technology and the history of them is near of this topic. You know, there's some regulations there for this topic can be more developed than in our countries. Well, global ethical principles. The adoption of set of global ethical principles for development and use of AI in weaponry promoted by international organizations can provide a common basis for state and non-state action. We have in America a regulation of this, in Europe another, in Africa other, in Asia other. Different international norms for a group of countries. Accountability mechanisms. Establishing the accountability mechanisms for developers, operators, This is very hard. And government involved in the use of autonomous weapon systems can help ensure that individuals and entities are held responsible for the violation of the law of war. Transparency and public control, promoting transparency, developing and use of AI and weapon, and ensuring a level of public and parliamentary control can help build trust and ensure that the development of these technologies aligns with ethical and legal values. Well, so just now talk a little about in Brazil. What we have something, what did well, in Brazil our state try to apply these principles and these strategies to guarantee the human use of the weapons when it was necessary in some war, any war. And in Brazil, we have in history this. I said to you, we don't have in the last century, Brazil was not involved directly in the war. So, but you need to have developing a force, a military force, because you are a very great country, and of course, Brazil needs to develop technologies to protect our country. It's very important. So, but you can think in Brazil, I'll be little. And so Brazil developed international humanitarian law in the AI area. In Brazil, it was very considered. Well, you know, the international humanitarian law, also known as the law of war, is a set of rules that seeks to limit the effects of armed conflict. It protects persons who are not or are no longer participating in hostilities and restricts the means and methods of war. Of course, the AI can be used to death and to protect life, both. You think about it, both this. And Brazil have the history of defense technology. During the 1960s until 1970s, Brazil initiates its aerospace program, developing aircraft and missiles. From in 1980s or 1990s, expansion into cybersecurity and digital warfare capabilities. And from 2000 to present, focus on AI and autonomous system military applications. Well, so Brazil journey's defense technology has been marked by a commitment to indigenous development and strategic autonomy. The history provides a strong foundation for the country's current endeavor in military AI, typical from our country. Well, in Brazil, we have some projects that were developed in this area too. Project Saci, Cyberlab, Mansup, the name of the project, AirVR. This project demonstrates Brazil's commitment, our leveraging, and all in enhancing its military capabilities while maintaining a focus on defensive and non-lethal applications. Our culture is very strong at this point. Non-lethal applications. It's very, in Brazil, people, our culture, put the top in good position. So what the principle of military or governance? Like in other countries, you put ethical use, ensuring all aligns with humanitarian values, transparency, accountability, UN control, and international cooperation. So Brazil advocates for these principles in international forums, emphasizing the need for responsible development and deployment of military AI technology. So I'll continue this topic. I think we are doing well this, but of course, all the time you need to pay attention what happened by our authorities, because so Brazil is recognized in United Nations, you and I, for these diplomatic initiatives, research collaboration, and regional cooperation. Because in South America, Brazil is the bigger country, so we have the responsibility to do better than our neighbor. This work with this topic, too. So, but now we have, but I think, and also how is in India, of course, money for this kind of military technology in Brazil is not so it's not so big the quantity as in the United States, as in Great Britain. I think so in India is the same, no? So integrating IHL, the Maritime Law, International Maritime Law, in military or AI development. So there is all our militaries are educated in AI developers, in humanitarian law principles, both of them. So our militaries are receiving formation for this in both areas. Ethical review boards establish here committees to assess AI projects against AI standards, AHL. We have in Brazil a project for AI, very great. It's running just now, and we have a lot of objectives to achieve until 2030. And one of these points is this, to use the technology only to do the best for human being. Simulating testing, rigorous scenario-based testing of AI systems for IHL compliance. Here, people are doing this. Continuous monitoring, ongoing evaluation of the deployed AI systems for adherence to IHL. So Brazil's approach ensures that international humanitarian law is not an outer but an integral part of the military AI development process. It's very good in our country. There's people, I think, in this topic. And so I think we can conclude about can talk about another project Brazil take part, but I think it's not necessary. And I think just I try to put to you what I heard about the other professor here and what I was thinking about to talk about. And with Brazil, I think our country just now is very important in South America to the position, and yes, just now I think the world, our authorities just now from militaries are very good authorities, and our people who works with Brazil with international law, humanitarian law, I mean, they are developing a great work here. But the dilemmas are so difficult, so hard. So we need to join because international people thinking is more than only on a country, and the topic is international because war in general with AI can be spread so easier. Bom, então I'm so sorry for my English not so good. For you, English is our language. For me, no, my second language. And I'm a little fever just now because in Brazil we have another wave of COVID. I think so. I don't COVID, but something like this. This month. Thank you.
Thank you, sir. Thank you so much. Despite of your health challenges and early morning, you have joined us.
Okay.
Thank you so much. We are grateful to you that you have supported us and even you represented your university for the collaboration. And thank you,
Thank
sir.
you.
Please keep this bonding alive with us. So
Thank
now
you.
we are privileged to have Miss Anastasia Jorel from Ukraine. She will speak on the Ukrainian academia, media, and military perspective on the use of AI in context of war with Russia. Before she takes the stage, I would like to request Ghana to introduce her.
Thank you, sir. Anastasia Jurel is a dedicated PhD researcher at the Hertie School's Center for Fundamental Rights, where her work critically examines the role of UN bodies, particularly the Human Rights Committee, in addressing individual applications regarding human rights violations during war. She contrasts this with the approach of the European Court of Human Rights using the ongoing Russian war against Ukraine as a case study. Anastasia holds an LLM in European law from the College of Europe, Belgium, and a bachelor's degree in international law from Taras Shevchenko, a national university of Kiev, that is Ukraine. Before pursuing her PhD, she spent 3 years working with NGOs, championing the rights of prisoners and Roma communities across Ukraine and Council of Europe member states. Today, Anastasia will share her insights on Ukraine academia, media, and military perspectives on the use of AI in the context of the war with Russia. Her talk will explore how AI technologies are being integrated into various domains in Ukraine, highlighting both challenges and opportunities in the context of an active conflict. We welcome you, ma'am.
Floor is yours, ma'am.
Good day, good evening, good morning to everyone. It's a pleasure for me to be here today and present the perspective of the Ukrainian society, Ukrainian media, academia, and military on the use of AI in the warfare against Russia in the current war of aggression of Russia against Ukraine. And I will start with the caveat that I will mostly talk about the situation and the state of affairs after the beginning of the full-scale invasion. So from 2022.
বলো এই তো এটা কোথায় এই তো ঢুকে গেছি ওই বিপত্তরের রাস্তাটায় টালিগঞ্জ বাড়ি টালিগঞ্জ বাড়ি আমার সেমিনার হচ্ছে দুটো সেমিনার আছে
Thank you. I will continue. So the Ukrainian Minister of Digital Transformation, Mikhailo Fedorov, called Ukraine a testing ground for military AI applications. And since the beginning of the full-scale invasion, various Western partners, private companies, and governments have assisted Ukraine in developing and employing the existing technology, new technology, AI-powered algorithms to support Ukraine in its defensive war against Russia. However, those applications pose complex questions on the compliance of this technology with international humanitarian law and human rights law. And today I will talk about which systems, the most popular systems, the most widespread systems that are being used in Ukraine, what could be the legal implications for the use of these systems, and how their use could be made compliant with the international legal framework. So I will now proceed to examine the current landscape of the use of AI in the Ukrainian defense, and then talk about what could be the legal implications for such use. First of all, there exists a very popular, widespread technology that is offered to Ukraine by Clearview AI company that is based in the United States. The CEO of this company contacted the Ukrainian government immediately after the beginning of the full-scale invasion and offered the services of this company free of charge to the Ukrainian officials, the military, which was a great gift, but also it poses great challenges. This technology is the facial recognition technology. It is able to conduct the analysis of the faces of the people on the pictures or the videos with the precision that is close to 100%. In particular, it's 99.85% of accuracy of the facial recognition. This technology was developed with the scraping technology of the photos and videos that are posted in the social media by the users. And their library counts for around 40 billion of photos of individuals. And I bet some of you have never heard of this company, and I personally have never given a consent to this company to scrape my photos on the social media, so as many other users have never given their consent for such scraping and creation of this database that is now being used by different actors, including the Ukrainian defense. So in the past several years, despite the fact that the use of this technology has been very beneficial to the Ukrainian military, in particular, around 230,000 individuals have been identified with the help of this technology in Ukraine in particular. Those were the Ukrainian soldiers, the Russian soldiers, the deceased people, even the collaborators. So it was a variety of individuals who were identified, including the children who were deported by Russia from the occupied Ukrainian territories, which is a great case use. However, since 2020, this company has been subject to legal proceedings in the European countries and was heavily fined by the data protection authorities in several EU countries like France, Austria, Greece, Italy, the United Kingdom, and they were prohibited from selling the database to the United States private companies. So basically, the way this company is collecting the data and the fact that it also does not allow for the erasure, the deletion of the information, that is this right to be forgotten, or the deletion of the private data of customers, or the people whose data is being scraped. All this has led to basically the acknowledgement that this company does not, its actions do not comply with the general data protection regulation in the European Union. That is, it violates the privacy of individuals who have never given consent to their data being used by this company. At the same time, Ukraine has been using this technology since the beginning of the full-scale invasion. The CEO of Clearview AI is planning to open the office in Kiev to have the base in Ukraine. The Ukrainian ministries of digital transformation, of defense are very happy with the use of this technology and are even considering using it outside of the scope of the warfare. They are already currently using it in law enforcement operations, for example, to look for the drug dealers. So this technology is already used outside of the warfare context, and they're also planning to extend the use of this technology to customs and banking, which means that we would need to consider the consequences of the use of such invasive technology in the peacetime. However, even in wartime, I would claim that the right to privacy of individuals, even on the battlefield, even the collaborators, can potentially be violated through this technology. And as we know, the international human rights law does not cease to apply during armed conflict. We could draw some fundamental principles and notions and rules from the human rights law to assess the legality of the use of this technology during the conduct of hostilities in the wartime. Then I would also like to mention the data analytics and targeting systems that I deployed in Ukraine. For example, Palantir, another American company, their Meta Constellation platform is actively used in Ukraine. It combines the satellite imagery, drone footage, and the intelligence information from the Ukrainian military to create the map, the digital map of potential military targets that are then used as a guidance for the military targeting. And this company is widely known outside of the Ukrainian context as well. But the CEO of Palantir, Alex Karp, has said that this system is now basically responsible for most of the targeting in Ukraine. So it's the focal point for most of the targeting decisions that are now made in Ukraine. And it's very good to look at what this platform is doing and whether it is compliant with the fundamental IHL principles and human rights law. It is basically giving the real-time picture of the battle space, and it is analyzing so many different variables and data pieces that a human being would never be able to analyze it that quickly. And the CEO of this company has called this system or this technology a kill chain, which means that it is practically impossible to verify whether the target is legitimate or not, or how the decision on this target has been made by the system. And this presents major risk because the human is not in the loop anymore, because humans are not able to analyze these amounts of data, and that would mean that the whole control is given away to the AI system. I will talk about principles and the compliance of the system further. Now, the last major use of AI in the Ukrainian military is the autonomous weapon system, and notably the drones that are AI powered. As we have heard from the news, Ukraine has become the new drone kingdom. There are still a lot of civilian drones that are being repurposed into military drones, the FPV drones. But the problem with the FPV drones is that they're very fragile, subject to jamming, which is the way of basically disallowing them their operation. They lose the signal, the connection with the drone operator, and they're not able to communicate back and forth with the drone operator. So the solution to that has been the creation of the AI-powered drones, such as the Saker Scout drones. This company was initially using the drones to watch the crops, but since the beginning of the full-scale invasion, they were repurposed into helping the military and developing the system to operate the drone without the need for communication of the drone operator. And basically, the drone identifies the target on its own based on AI algorithm, and then conducts the operation on its own. Again, here the problem is this kill chain. The drone is conducting the operation on its own without human oversight, and there is no guarantee that the drone would be able to identify military targets correctly, and that all of the principles of IHL, like distinction and precaution and proportionality, would be also complied with during such operations. While this technology is currently being used in conjunction with the drone operators, the employees and the head of this Saker company confirmed that usually this drone, although AI powered, is used with the human in loop. So humans are controlling this technology. They also confirmed that in some occasions, currently very rare occasions, when there is jamming happening, so there is no connection between the drone operator and the drone itself, the drone is conducting operations without human in the loop through just AI-powered technology, which means that it is already happening, that this autonomous system is acting on its own. And we don't have data, don't have evidence to analyze whether such operations are compliant with IHL and human rights law, which represents a huge risk to the detriment of IHL principles. So Now I will talk a little bit more about the compliance of all these systems with the IHL principles. The first principle is the principle of distinction, which is enshrined in Article 48 and Article 51, paragraph 2 of Additional Protocol 1, which requires parties to distinguish between civilians and combatants. As we have discussed previously, the secure drone system, for example, while it can identify military targets, we do not know whether it can ensure that its algorithms can reliably distinguish between a civilian truck, for example, and a military vehicle. We already have had reports of other AI-enabled drones misidentifying civilian vehicles as military targets because they are visually similar. So we cannot be, as lawyers and practitioners, we cannot be sure that those technologies are identifying those targets without errors. And some of the companies are claiming that they are conducting tests, and they are also verifying a lot of the data to make sure that there is distinction, but most of those tests are kept in privacy, so to say. They are not disclosed, so we do not have access to those materials that would confirm that these systems actually comply with the principle of distinction. Then we can also talk about the principle of proportionality that is enshrined in Article 51, paragraph 5 of Additional Protocol. This principle prohibits attacks where the civilian harm would be excessive compared to the military advantage. We don't know whether the systems that are currently used in Ukraine are compliant with the principle of proportionality. One can see that in the urban warfare that is also happening in Ukraine, when the Russian troops are entering the cities and the villages, and there is this fight in the middle of the city, it's very hard to strike a balance even for the soldiers. But for the AI, it depends on which data it has been trained, because some of those systems, some of those technologies are trained on artificial data that does not take into account the ever-changing context of the military activities, of the so-called fog of war, when there are a lot of actors, they are moving fastly, they are also unpredictable sometimes. So we should be sure that the data on which those AI-powered technologies are trained is actually representative of the real life battlefield context. And the problem with AI systems is that they are also limited to the knowledge they have received during the training. And as the previous speakers have also rightly noted, that they do not have sometimes this capability of seeing with the human eye and identifying the context and making fast decisions that are based on here and now. They will always be basing their decisions on the previously acquired information and the analysis. So yeah, in terms of proportionality principle, one of the crucial parts is that the human should be included in the decision-making process because it's very hard to transfer ethical and moral values to the machines. And as we also mentioned before, there has been a call of the United Nations Secretary General and the head of the ICRC, the president of the ICRC, to ban autonomous weapon systems that do not have a human in the loop. And some of those systems are still currently in use, both in Ukraine and in other countries, in other conflicts. So while there is no legal regulation, legally binding convention yet that would ban such systems, we already see that it is not safe to use them without a human in the loop. It is not possible to verify whether the machine has made a decision that is compliant with IHL, and then the humans would be practically useless in this process because they wouldn't be able to effectively verify whether the target was legitimate or not. So there will be over-reliance on algorithmic recommendations, and lack of human judgment will lead to increasing chances of civilian casualties and errors that will then, we are not sure to whom we could attribute them, to the algorithm, to the programmers who developed the algorithm, to the soldiers who are using this algorithm. So then there will be a question of accountability and responsibility that is not clear yet. Finally, the precautionary principle that is the core of today's discussion, that is detailed in Article 57 of the additional protocol to the Geneva Conventions, requires the forces to take feasible precautions to minimize civilian harm. And while the Ukrainian forces are using a Palantir AI to verify the targets and make sure that they are not civilian objects. Once again, we are not sure, and the companies that are providing these services are widely and heavily advertising the accuracy of their algorithms. However, in the battlefield, we are not sure how accurate those algorithms are, and there is no evidence that those algorithms are more accurate than human decision-making process in the real-life situation, because those percentages that I presented earlier are very much dependent on the context, on the situation of when the test has been taken. And Article 36 of Additional Protocol 1 requires state to conduct a legal review of the new weapons. And this might not be even sufficient to prevent these technologies from violating IHL. However, these tests have to be conducted to ensure that the state knows which technologies it's using and what could be the risks and legal implications of the use of such technologies. Finally, I'll briefly talk about the human rights that are also endangered by the use of such technologies. Firstly, it's of course the right to privacy that is protected under Article 8 of the European Convention on Human Rights, while Ukraine has partly derogated from the European Convention on Human Rights since 2014, but also since the new stage of the war. Those derogations are very limited in scope. They do not concern the widespread facial recognition technology or identification of individuals. So one could say that the scope of Article 8 applies to the Clearview AI facial recognition technology still, and bear in mind all the heavy fines that were awarded to Clearview AI and the fact that many European Union regulators are strongly against the use of this technology. Many civil society actors in Ukraine are recommending the Ukrainian armed forces and the Ministry of Digital Transformation to reconsider using this technology to ensure that it does not violate the right to privacy of individuals. However, realistically speaking, most of AI researchers and technologists would agree that such invasive and intrusive technology cannot practically comply with the privacy of individuals. So the only way to prevent a violation is to ban the technology altogether. However, here comes an ethical and moral consideration, is that Ukraine is fighting defensive war, and Russia is conducting an aggression against Ukraine. There are hundreds of thousands of victims and casualties. So the question here is whether it is legitimate to violate certain rights when the very existence of the state is questioned, is endangered. This is a more moral, philosophical question, and of course, we could understand that the Ukrainian government and the military are not going to get rid of this technology until the war is over. However, its use outside of the military and warfare context poses great concern, and that is something that the Ukrainian authorities can control and can ensure that this technology is not used in the civilian life to track, identify individuals for various purposes, even if those are the law enforcement purposes. Because here in the human rights realm, in the civilian context, the right to privacy should be definitely protected and ensured and guaranteed in accordance with the national framework, which should also be updated in accordance with the GDPR in the context of Ukrainian accession to the European Union and the national legislation that is unfortunately still not updated since 2010, but it already contains the crucial guarantees to the right to privacy of individuals. So one could say that this technology should not be used in the civilian context. That is for sure. And maybe just a little bit of an additional information on the right to life. While there is a discussion in the literature whether the right to life should apply to combatants or should only extend to the civilians in the context of armed conflict, it is already clear that the use of AI-powered technologies where human is outside of the loop and we could not guarantee that the target was identified correctly, only this fact already poses a huge risk to the right to life of civilians in the context of armed conflict. And yeah, there is already a huge risk to the right to life that cannot be mitigated effectively if the AI systems are being used in the battlefield and there is not enough information in the public domain for us to be able to assess whether these systems are compliant with the right to life of individual and the principles of IHL. I will conclude here, and I'm grateful for the floor, for your warm welcome, and looking forward to the continuation of our fruitful discussion. Thank you.
Thank you so much for your comprehensive deliberation. I would like to ask you a question, since Ukraine is also engaged with the war. So what do you think about the involvement of AI with regard to ongoing conflict that impacts environment. And I have read some newspaper that Ukraine has taken certain initiatives to claim compensation from Russian. How you determine this to claim such? So the same thing, since I am hailing from Afghanistan, where Russian bombed Afghanistan to since 1979, about I could say more than 8 years. First, the war was just between the Russian, what we call Soviet Union, and the Afghan people. Later on, the Russian army thought that in order to disable the people, they used sorts of chemicals that on the lands and soils. So in the way that they made the land and soils, even in terms of agriculture, so that people were feeling the starvation and depend on others. So they want to disable in that way. What about the Russian operation in Ukraine, comparing Afghanistan situation and the present conflicts, what is happening there?
Thank you for your question. That's indeed a very important topic. I would say that the existing framework is not sufficiently developed, both in the IHL and in the human rights law. However, the current development of international environmental law is posing some hopes. There are also talks about including ecocide as international crime in the statute of the international criminal, in the Rome Statute of the International Criminal Court, and unfortunately, the states usually have the main focus on the material damages, and then we have human damages, the damage to individuals, their life and health, or emotional well-being, psychological health, and only after that we talk about environment, unfortunately. And I would say the claims for compensation will definitely be considered, but we do not know how to assess the damage, because the damage to the soil, the damage to the environment is so great sometimes that the whole state budget might not necessarily cover those damages. So then comes the question of the feasibility of getting the compensation. If this damage to the environment will affect future generations, then it would mean that the state, the Russian Federation, would need to pay this compensation for many dozens and maybe hundreds of years to come, because the environment cannot regenerate itself that quickly. And this, of course, is one of the methods of warfare that the Russian army has been using consistently in different parts of the world. My opinion is that there should be a clear norm in the Rome Statute on ecocide, and other branches of international law should also develop the frameworks that might not necessarily attain the level of a war crime or the crime against humanity, but would nevertheless cover the environmental damage to the territories that are being fought against, and where the warfare is happening.
Right. I'm looking for question from audience. So we are very particular about Ukraine situation. Is there any questions? Are there any questions? Yes, we see none. Thank you so much, ma'am, for joining us. Thank you so much. You're really spoken and you're given thought-provoking. Yes,
Thank
insight.
you so much.
Thank you so much. So now we have another presenters, Mr. Rahul Cardellini, who is going to join us after 10 minutes. Since we're online, I think we cannot go so longer. Without further ado, we will conclude today's session. Now, I would like to request esteemed Principal of Jesus Law College, Dr. N. Wanishri, to give a vote of thanks to esteemed speakers and participants. And thank you for your attention and participation for this timely and important webinar. Ma'am, the floor is yours.
Thank you, Mr. Syed Kudrat. Good evening to everyone. And I think the beginning was too good. And after fruitful discussions and wonderful thoughts given by Professor Srinivasulu NS, Dr. Kenneth, Dr. Antonio George, Dr. Anastasia, of course, we had to hear from Mr. Rahul and we couldn't. And the others, of course, it is my duty as a host to extend the sense of gratitude to each one of you who have spared your valuable weekend, I would say, with us in sharing your thoughts on this very significant topic, I would say, and also the role played by the legal luminaries and the legal people towards finding a solution. And I'm sure the second day of this webinar would give us more thought for food on this area, especially with the different paper presenters with their researches done, and looking forward for another successful day tomorrow. I once again thank every one of you present here with us, online and offline, and especially the organizers who have joined with us, with our college, to bring out such a wonderful program. Thank you, one and all.
Thank you so much. We have shared the Google form for the participants. Please do fill that. After filling that Google form, we are able to issue you the certificate of participation. That includes for today and tomorrow. Thank you so much for your rich participation. We hope to see you tomorrow. Tomorrow we will start the program by 10 a.m. Right. Thank you.